Hello, it's Philip Taylor speaking from Richmond Green Chambers in London, and this afternoon I'm looking at a book which has come to us from Elgar Publishing Limited. It's a family firm of publishers, and they produce some very high quality top-end academic work, and certainly a large amount of work in the international sphere involved with things like intellectual property and a whole range of other very, very current matters which I think affect both the national and the international communities. Now, my wife Elizabeth and I have written a review of a book we're looking at today, and that is called Patenting Medical and Genetic Diagnostic Methods, and it's been written by Eddy D Ventose. Now, we've given it a review title. We've said, should new medical procedures be patented? This book leads the debate. I hope that's got your attention so far, because when I looked at this book I didn't really understand what was going on. I do now. This is the front of the book here. It's only a very small book, it's a hardback. There's the spine, and then at the back you've got quite a lot of detail about the author, about what they say about the book and so forth. The book is actually 250 pages at the very most, not even that. There's a little index, 210, 12 pages, something like that. There's the index. Not a lot of the index, but what there is of it is extremely helpful. Then you've got at the back, the way this is structured, you've got a nice little bibliography. Again, not particularly long, but you've then got the chapters themselves. Let me just give you an example. There's a conclusions chapter at the back, because it's running through this book is running through with a particular theme. The title, Patenting Medical and Genetic Diagnostic Methods. That's the title, very interesting one. Professor Ventose mentioned at the front there. Then you've got the contents. You've got the various chapters. There's a preface to look at the beginning. 7 chapters, that's the conclusion. Then you've got the preface itself. He starts the issue of patenting medical procedures, whether therapeutic, surgical or diagnostic in the US. It's been in a state of flux for over 100 years. That's where the book comes in. The useful abbreviations, not very many of them, but enough. Some cases, so there's a little bit of case law involved, international stuff, legislation. Then you have an introduction, and again there's some footnotes at the bottom which are quite helpful. There's no paragraph numbering, but you do have subheadings and ABC and so forth running through. So that's what we've got. Let me just tell you about the contents so that you've got some idea, because there are only 7 contents: introduction, initial determination, legislative intervention, patent eligibility, consideration by the Federal Circuit, consideration by the Supreme Court, and then conclusions. Let me talk about the book, because it's a fascinating area for patent or patent law, apart from anything else, and very much again something that the 21st century is going to turn to in a much greater amount of detail. We have a much more literate society, a much more global society, a society that knows its rights, obligations, we hope, and aspirations. So what we're looking at here, remember the title, should new medical procedures be patented? That's the question that's being posed, and this is what we say. New developments in medical procedures, including new diagnostic methods, are frequently reported in the press and the media. But what is not widely known is that innovative medical procedures can be patented. Now, what Professor Eddy Ventose has come up with, he's the author of this carefully researched book. He lists just some of the methods that are patentable, to include, for example, methods of treatment, dosage regimes and methods of assessing their effectiveness, surgical methods and general diagnostic methods. Not something I'd ever thought about before, I have to say. It's an area that I hadn't really given any thought to at all, which is why it's so interesting and so something completely new to me in terms of what one might be considering for patenting. The publishers, therefore, Elgar, point out that this is the first book to provide comprehensive coverage and commentary on the patenting of medical procedures. Yes, the book explores and examines the issue of medical and diagnostic methods patented almost exclusively in the United States of America, where this issue has generated controversy for over 100 years, which is what he says right at the beginning. Because I had no idea of this, and I'm sure many people had no idea either. The book's content, however, should interest practitioners worldwide, including solicitors, barristers, patent attorneys and agents working in patent and medical law. And the book is particularly, I think, topical and indeed future orientated in the wake of the mapping of the human genome in the year 2000, which has since opened up new avenues of medical research. And this century is about that. No question in my mind about it. That's where we're going for these generations, all the people following me this century and into the next century. That's what will be happening into the 22nd century. Such research initiatives will in turn lead to the development of more new medical procedures and ultimately, as observed by at least one commentator, the dawn of a new era of personalised medicine. Now, that is quite interesting because, as I said, you work on the basis that this century is going to be about medical advancement. And we know such a small amount of what's there to be known at the moment, what's to be assessed, that this is the start of it, I think. The author traces the legislative history pertaining to these issues, including the decisions of the early courts, and considers carefully the jurisprudence of the US Supreme Court on patent eligibility. An authority in this field, Professor Ventose, is a professor of law and a specialist in IP, and the book follows, and one can assume expands upon, the themes first addressed in his doctoral thesis at Oxford University, when he got his D.Phil. Obviously, the issues dealt with in this book impinge on public policy and a host of ethical considerations, including whether or not it's entirely desirable in principle to patent medical discoveries in the first place. Well, is it or isn't it? Think about that, because the answer is yes, it is, and it's going to continue, whether you probably like it or not. And that's one of the reasons why these people are pathfinders for what could well happen for the rest of this century. On matters as crucial as this, opinions will invariably vary, which is why the book, we think, will be of abiding interest to a wide readership, not just confined to practitioners, and I think it will have some form of historic relevance in a couple of decades' time, probably, when we may be taking a lot more of this for granted, whereas at the moment it's effective, if you like, in its infancy. So let me conclude by saying, for researchers, the table of cases and of national and international legislation are particularly useful, and of course there's a host of handy references to be gleaned from the bibliography and the footnotes which are throughout. Not too many of them, by the way, which is helpful, but enough to give you the academic clout should you need it, depending on what doctoral thesis you are producing. For anyone, therefore, involved in intellectual property, medical law or patents, this book should be considered, we think, an essential purchase, and the publication date is cited at 2013. I reviewed this in 2014, and we are developing all the time, which is why I've said it's got an importance of its own. That's the book, spine, and then the back. It's, as I say, a light book. It's not that difficult to read. No disrespect to, well, there's the middle of the book, no disrespect to Edward Elgar, but they know as well as I do that some of these books, not the easiest books in the world to read, found this quite interesting. I liked the conclusions. Remember that you've got to have a little understanding of how the American US system works, about federal circuit courts and so forth, but I wouldn't worry too much about that. They mention a few cases, but the point about this is that this is something which is starting and it's going to develop. That's my suggestion here, that it's going to develop, and therefore it's something that we should think very seriously about. I'm grateful to Edward Elgar. They maintained the highest standards as always. We are reliant upon them, certainly in the academic community and in the practitioners' community, to have works of this nature, depending on the type of cases we might get, which we are, asked to advise upon. So thank you to all concerned, to Professor Ventose, fascinating area, to Edward Elgar and all involved. Thank you very much indeed. It's a great contribution to the ongoing debate. Bye-bye.